Okay, so how are you guys? And well, welcome back to another episode of our live class. Right now, where we are talking about innominate terms or intermediate terms on the contract. Do not forget that our first class under terms of contract, we talked about the difference between terms of contract and mere representations, right? That was what we talked about in the first class. In the second class, we talked about the difference between conditions and warranties, right? In today's class, we are talking about what are innominate or intermediate terms. Do not forget, I told you that under terms of contract, we have four types. We have conditions, warranties, innominate or intermediate terms, that's one, and fundamental terms, that's the last one. And fundamental terms is the last topic we would have before we start talking about implied terms. Everything that we have been talking about are those that have been expressly stated by the parties. So when we talked about conditions and warranties, they are clauses or statements that has been expressly stated by the parties. Now that we are going to talk about innominate terms, they are expressly stated by the parties. When we'll be talking about fundamental terms in the next class, those as well are expressly stated by the parties. Now, I know that the light right now is not as bright as it was, for the first and second class, and that's because, Nigeria has happened again, and there's currently no light. So sorry about that. We hope that during the course of the lecture, which is supposed to last approximately about an hour, we hope that during the course of the lecture that we are going to have light again. But as at now, we are going to live in Nigeria as as it is. So for those who are just joining us for the first time, standing before you is Olayeni Dear Kolola Daniels, popularly known as Dearco Spectre. And welcome to another episode of Dearco Talks Law, where I talk about the law of contract, particularly innominate or intermediate terms, in terms of the specific topic on the terms of contracts. We are talking about innominate or intermediate terms. So, when we're talking about conditions and warranties in our last class, we made mention of the fact that when you are referring to warranties, what do we say are warranties? Things that are just collaterals to the contract. They are not the main contract itself. I noticed that in the last class, I gave an example which I did not answer. Do you understand? The example of A and B. A is supposed to pay 500,000 to B for a cake that is supposed to be 3 layers. Here is supposed to be red velvet. Here is supposed to be chocolate, and here is supposed to be vanilla. While A says that you must give it to me on the 7th, right? On the 7th of December, because my birthday is on the 8th, right? And then another thing is the subject matter, which is the cake, right? And another thing is C is the arrangement, right? So now if we look at what we spoke about in the last class, if we look at it closely, we would see that where we say something is merely collateral, can we say that this particular statement is merely collateral? That means that if you don't deliver the cake to me by the 7th, my birthday is on the 8th. If you don't deliver the cake to me by the 7th, can we say that it is not a collateral thing? And if it is not collateral to the contract, then it's a condition. Do you understand? So now what I would say is, if the person doesn't deliver it on the 7th, the person doesn't deliver it on the 8th, but the person delivered it on the 9th, what are we delivering for exactly? Except it was not made a term of the contract as to you are doing it for the birthday. If you let that person know that your birthday is on the 8th and that's the reason why you are getting the cake, then if it's not delivered on the 7th, if it's delivered on the 8th within a reasonable time, let's say it's delivered like 6 a.m. on the 8th, we cannot say that there has been a breach of contract, right? Because you want to be doing birthday around 3 a.m. Do you get? But if the person now delivers it around 9 p.m. on the 8th, do you get? Like, what are we celebrating again, especially when the person had gone to get another cake? So therefore, it is obvious that this is a condition. Why? Because where it is breached, if you deliver something to me on the 9th, what am I now using it for? Do you understand what I'm saying? So now when we look at the subject matter, when we are talking about the next class, you will see that under subject matter, if I tell you to deliver cake to me and then you deliver something else which is not cake, it goes to fundamental term. I will discuss that in the next class, which is going to be our last class for today. I will discuss that in the next class where we'll be talking about fundamental term. And then the arrangement where I told you to put red velvet up, and then you decide to not put red velvet up, you decide to put vanilla. Now, if the person sends the cake, but now put vanilla, which I told to put down, it's a 3-layered cake, right? I told you down should be red velvet, middle should be chocolate, up, down should be vanilla, up should be chocolate, and middle should be red velvet. And then instead, you now alternated it. Red velvet is down, vanilla is here, chocolate is up. Now, if you send that to me, does that take away, is that so important into the contract? Do you understand? That is a mere warranty. Do you understand? Which you can sue for damages and say, because of that, give me so amount of money, because this is not what I told you. Give me, do you get? But you cannot say that you are repudiating the contract merely because the arrangement is wrong. Do you understand? So I noticed that I did not give you this breakdown, and I don't want to skip it in this class before we go. So I hope that you understand this breakdown very well. I will explain it more as I'm talking about the definition and all that of the innominate or intermediate term. So let's go to our notes where we talk about the definition and all that. How many minutes right now? How many people?
15.
Okay, so I'm trying to get my note on my system. Just give me about a second. Are you reading notes? Loading. Yes, so now innominate term, let's go straight. Now, in more recent times, a new term has been evolved by the courts, which is really a hybrid between a condition and a warranty. A breach of terms within this category could lead either to damage or to repudiation, depending on the effect of the breach, if the breach is so devastating as to deprive the injured party of substantially the whole benefit which it was the intention of the parties that he should obtain from the contract. Then the remedy would be repudiation. Otherwise, it would be damages. The existence of an innominate term was first vigorously canvassed in the Court of Appeal case, particularly by Lord Diplock. He was the person I was trying to remember when I said Lord Dixon in the last video. So by Lord Diplock, Diplock, by Lord Diplock in the case of Hong Kong. So this is what we are talking about now. We are talking about this case, Hong Kong for FIR Shipping Co. So I think I see HOLGKONG FIR, then Shipping SHIPPING versus Kawasaki KAWASAKI, Kawasaki Kisen KISEN, Kaisha KIASHA. So you see, when you're talking about innominate terms, these are extremely important things for us to look at. Just give me a second. Quite dark. So yes, as I was saying, this is a very important case. If you are talking about innominate term and you want to cite it in exam, don't forget that if you are talking about conditions, I already told you that when you're talking about conditions, Pym and Campbell and all that, and I think there is this Pulsard and Spears and this thing and Guy, can't remember the name, but there are certain cases, Bettany, yes, there are certain cases that you must know as a matter of fact. Do you understand? So when you're talking about terms, these are locus classicus cases. You don't need to go and start researching in your case. This, in fact, you barely find it. And I don't think it's important, except your lecturer specifically gave you those new cases. It's not important for you to go and start doing research. If you know that you love contract so much or you love books so much and you want to do research, when you are done with your contract law exam, you can then sit down and start writing your book. No problem. But if you want to pass a contract law exams, these are, important cases that must be cited. Do you get? Once you cite these cases, you get your B or A depending on how effective you were during the course of the exams. So let's continue with what we're saying. So Hong Kong Fair Shipping Co versus Kawasaki. It's just like, somebody has an exam and you are a lecturer, and then you look through it. It's on an innominate term, and the person does not cite Hong Kong, and the person is citing one. Do you understand? So these are very, very important things. Now, the defendants chartered a ship from the plaintiff for 24 months on time charter for cargo services. If you have gone through my privity class, I recorded close to 20 videos there about on privity. If you've gone to my privity class, you would see that I said it most times that when we are talking about ship, you are basically saying that you want a ship to go from point A to point B, and let's say in this case the vessel was delivered and it sailed from Liverpool. So the vessel was supposed to go from Liverpool to where? To in the United Kingdom to Newport, right? That's the case. The vessel was supposed to go from Liverpool to Newport in the United States and loaded cargo of coal for Osaka in Japan. Now, they wanted to carry cargo of coal. You can see the subject matter of the transaction is not coal. The subject matter of the transaction is ship. The ship which they rented for 24 months. 2 years. They rented a ship for 2 years, and the subject matter was to deliver goods from one place to the other. Do you follow? They rented a ship for how many years? For 2 years, to deliver coal from one place to the other. And what's the place? From Liverpool in England to Newport News in America. Let's continue. Now, the room staff were incompetent and the engines were old. The ship broke down and was held up for 5 weeks on the journey to Osaka. They were supposed to deliver the stuff at Osaka. Sorry, let me get this straight. So, United Kingdom to Newport News and loaded a cargo of coal for Osaka in Japan. Yes, so it was supposed to go to Osaka rather. Sorry. It went from Liverpool to New York. To New Port Wales, and from New Port Wales it was supposed to be to Osaka in Japan, right? So good. So while on its way to Osaka in Japan, the ship broke down, and then it held up to 5 weeks on its journey. So and then on arrival there, it was discovered that the further repairs could take another 15 weeks for something that they chartered for 24 months. So before it got to Japan, it took 5 weeks on the road. It broke down, they repaired it. When it got to Osaka in Japan, they now told them that for it to be fully functioning again, to move, it will take another 15 weeks. For a ship that I rented for 24 months, if it's taking all these weeks for repair. So, what am I doing here as a business person? If you are a business person and one ship is delaying you for the next 15 weeks from making money, the next thing that comes to your head is you want to repudiate the contract, collect your money if you have paid money to the person, or if you have not paid money to the person, go and look for another ship that is going to, do you get? In the next 1 week, you're going to find another ship that is working well. Do you understand what I'm saying? So, on arrival there, it was discovered that the further repairs would take 15 weeks. The charterers repudiated the contract for this reason, even though the contract still had about 20 months to run. In an action brought by the owners for wrongful repudiation, Salmon J at the trial court, when they got to the trial court, Salmon J found that the vessel was unseaworthy, having regards to the engine staff, but that the owner's breach of contract did not entitle the charterers to rescind the contract, and that the contract was not frustrated. On an appeal to the Court of Appeal, Lord Diplock, instead of Lord Diplock to look at things from the perspective of condition and warranties, Lord Diplock said no. I am not looking at it from condition or warranties. I want to bring my own new term. And then Lord Diplock brought innominate or intermediate term. Let's listen to what Lord Diplock said. Lord Diplock said that, in what event will a party be relieved of his undertaking to do that which he has agreed to do but has not yet done? Now, this is what Lord Diplock is saying. You have a and B, right? A is the owner of the ship. You gave the ship to B. That B should carry it from Newport or something, let's say from US to Japan, right? Now, when he got to Japan, he now saw that he was unseaworthy and all those kind of things, and he said he wanted to repudiate. Lord Diplock said, in what event will a party be relieved of his undertaking to do that which he has agreed to do but has not done yet? When can B say that, oh, I am going to be relieved of my undertaking to pay you, which I ought to do? At what point would B be relieved to do so? As a contracting party, at what point would the innocent party be relieved and say, I want to repudiate? That's what Lord Diplock is saying. In short, in what circumstance does such a party have a right to repudiate the contract? Exactly. In what circumstance does such a party have the right to repudiate? Now, he now said that the test, according to him, that's Lord Diplock, was the same in every case, whether it was a result of breach due to the default of one party or the frustration where no party is at fault. Now, if we are looking at it, he said that for this guy to be able to repudiate, it could be either the fault of this guy or it could be the fault of no person at all. Let's say act of God or something within the not within the fault of either one. Do you understand? So there could have been a third party circumstance which did not affect any of. Let's say when the ship was going, there something happened on the road. Let's say bomb attacked the ship. Is it A that caused bomb to attack the ship? No. Do you understand? Like anything could have happened to the ship. Maybe bandits came and blew the ship up. Do you understand? So if what he said, let's go, the test according to him was the same in every case, whether it was a result of breach due to the default of one party or to the frustration where no party is at fault. So now, he now said that the test is this is the test, and I highlighted it in my notes. Does the occurrence of the event, that's the breach, deprive the party who has further undertaking still to perform, that's the innocent party? So does the breach deprive that innocent party of substantially the whole benefit which it was the intention of the parties as expressed in the contract that he should obtain as the consideration for performing the undertaking? Now, as what he's saying is this, as that event that has happened, whether the event was as a result of A or by a third event, like a third party event, but the event itself, is it such that it must have deprived B of the substantial benefits that B was supposed to get from the contract in such a way, listen to me, of the substantial benefit which was the intention of the parties as expressed in the contract that he should obtain as consideration for performing the undertakings? Do you understand? So let us put it in perspective. What is that event? There are two events here now. We are talking about what is the substantial benefit. Do you understand? The substantial benefit to the main contract. What is the main contract? 24 months, I want to use this ship and I want to sail around sending goods from one place to the other. That is the contract. Now, the question then to ask is the substantial benefit of sailing around, has it been taken away? Do you understand? It hasn't been taken away because you still have the ability to sail around. That's the way I thought about it. The question is not whether or not he can no longer sail around. If he can no longer sail around, that's another question. The question is, he can sail around, but he can't sail around as fast as he wants to. Do you understand? He wants to sail from Japan to New Zealand to Iran. Do you get? He wants to sail from countries to countries as fast as he can. as fast as he can rather, but he can't do that because the ship is not letting him do that. But the question is, has the ship stopped him from stealing an at all? No, it hasn't. So the substantial benefit is whether or not you can sail around. Can you still sail around? Yes. So now let us look at applying the whole thing. Now, if it does, Lord Diplock said, if it does, then the injured party can repudiate the contract. Otherwise, it can only seek for damages for the breach. Now, since this new scheme was phrased in such wild terms, that's to continue with my note. Since the new scheme was phrased in such wild terms, what was the place of conditions and warranties in it? Or had they've been eliminated by the new doctrine? There's a question as to whether or not do we still have conditions and warranties, or should we just begin to look at contracts from the angle of where should we repudiate? Because according to what he's saying, he's bringing a new term. I need you to understand something. He's bringing a new term. You know that what I told you previously, where are those additional markers? Are they somewhere around there? It's not here. Oh, thank you. So what he's saying is this. You know that I told you that when you're looking at something, you look at it from the angle of what, then you come here, nature, right? Then you come here, effects, right? So what is the thing in context here? Whether or not the ship which he rented, which has been breaking down, right? Whether or not it would the clause is that he rented the ship to be going from one place to the other, and that is the essence for renting the ship. Now that he cannot go from one place to the other as much as he wants to, what kind of breach is that? Is that a breach of condition? Is that a breach warranty? Or is that innominate term? Now in this case, they are telling us that it is not condition, it is not warranty, it is innominate, right? So if we are looking at innominate, right? Rather, if we are looking at innominate term, now what is the nature of the term? Is innominate. Now what is the effect of the breaking and innominate term? They now has two effects. Condition has one effect, repudiation or breach or damage. Warranties, damages. But here, if it is such that it is against the substantial benefit, right, that the innocent party would substantially be deprived of the benefit of the contract, that is when you can what? Repudiate. Are you seeing? For condition, one thing, repudiate or damages, depending on what you want, or both of them. For warranties, right, go straight to the point, damages. But for this one, once we see that the nature is what? Is inanimate, we still have to look at the effect. The effect is still dependent on whether or not it has been substantially deprived of the benefit. If it has been substantially deprived of the benefit, that is when you can repudiate. If it has not been substantially deprived of the benefit, then what you do is damages. So basically, they incorporated condition and warranty in the innominate term. Do you understand? In fact, you can even say that it's still condition, because the reason I will tell you that it's still condition is because you know that in condition you can repudiate and ask for damages, but that's just going to be this part, because here you can repudiate and ask for damages as well when it has been against substantial benefit. Repudiate and ask for damages. So when you look at damages alone, that is what warranties will do. So the both of them is just basically, this one seems like conditions to me, this one seems like warranty to me. Do you understand? So I don't know why he evolved this rule, but I think we will continue to go to see why he evolved the rule and how we can juxtapose this rule in relation to conditions and warranties. So when we are looking at whether or not it has taken away the what is it called, conditions and warranty, let's continue with the notes. According to the court, although there are many simple contractual undertakings which could be identified per se as either conditions or warranties, there were, however, many other contractual undertakings of such a complex character which could not be categorized as either conditions or warranties. It is to this third group of cases that the test of substantial benefit is applied. This is what they are telling you now. They are saying that when do we use innominate term? When do we begin to see something as innominate, rather? I don't know why I keep saying innominate. So innominate, yes. So when do we see terms as innominate, so to say, or intermediate? When do we see terms as innominate or intermediate? We see those terms as innominate or intermediate when they are too complex. Listen to me. When they are too complex that you cannot categorize them as condition or as warranty, then you look at it from the angle of innominate, or innominate rather. You look at it from the angle of innominate. When they are what? Too complex. When you are saying too complex. Now, this is what we are talking about. Condition, straight to the point, right? Warranty is straight to the point. But innominate, it's not straight to the point. It's like this, but it has babies. So, for example, the question is seaworthiness, right? The question is seaworthiness. Now, that's the essence for the repudiation. They are repudiating because what is it called? The ship is said to not be seaworthy. Then you begin to look at what are those other things to consider. You have to consider the engine. They said the engine was old, and that was the reason why they keep repairing. You have to consider the workers in the engine room. They said the workers in the engine room were inefficient, and that's the reason why instead of us to go in so time, we are not going as much as we are supposed to. Now you can see that there are other things. So this makes it a complex transaction as to determine what seaworthiness is. Are you following me? But where it is simple that I can say, this is a condition. Straight up, this is a condition. Oh, this is a warranty. Straight up. It's not that they have complex, For example, let's come back to this. What are we looking at here? We're looking at dates. When should you bring the cake? Bring the cake on the 7th. Isn't that straightforward? If you don't bring the cake on the 7th and bring it on the 9th, why are you bringing the cake to me on the 9th when I told you to bring it on the 7th? The date there tells you on the 7th. My birthday is on the 8th. So why am I having a cake whereas I bought another cake already? So don't bother bringing it on the 9th because you did not give it to me. Do you understand? When I needed it. Now, can you see how that is straightforward to be a condition? Now, look at arrangements. I want red velvet up, chocolate here, vanilla here. But then they mixed it up. And then they put, let's say, red velvet down, vanilla here, chocolate up. You can see, because the arrangement is not the way I told you to make it, then I repudiate the contract. That's straight to the point, right? And because straight to the point, you can easily categorize it as being a warranty and not a condition. Let's look at the case of Bethany and Guy. They said come for this thing between so days for our training, for our show between so days, but you must also come for rehearsals. In Bethany and Guy, the rehearsals was for 6 days. He didn't come for 4 days, but he came for 2 days. We can classify, can those 2 days amount to, but in this case we can't necessarily classify what is seaworthiness until we take into cognizance what would be the engine. Is it good or bad? What's wrong? So until we take into consideration what will be the engine, whether old engine will amount to this, what will be the essence, the workers, whether their incompetence will amount to. Do you understand? So there were other factors that we then have to look. We cannot begin to classify this as condition, this as warranty. So because we are looking at other factors and because it is so complex, then another thing that I was saying, which is my own opinion actually, I don't think you find this in the textbook. I think that because the time that the innominate term becomes triggered to me is when it is not clear within the parties, when the parties were contracting what to be a condition. Do you understand? It is when you skip that step of what the parties have clearly said between themselves that this is going to be a condition. When you skip that step, and then when the courts now want to begin to ask whether or not this is a condition, that is when, and then it's too complex. That is when we now begin to look at innominate terms. But if you are clear from the onset of the transaction, this is a condition, right? This is a condition, a breach of which will amount to repudiation. Then the court is likely to respect it other than, begin to look for this and that. So the reason why Lord Diplock did not go straight to the point to saying that it's a condition It's because there were so many things to be read into it. And you cannot begin to read engine, whether or not the engine is old, this thing, whether, do you understand? The seaworthiness had so many elements. It was not straight to the point like this. Warranty, straight to the point. So when things are complex, the court is likely to use the whole innominate term and all that. But when things are straightforward, then use condition or warranties. And you know, even if things are complex, but they have cleared it amongst themselves, this is my own submission. If things are complex and they've cleared it amongst themselves initially when they were having their contracts concluded, then the court will respect them well enough to honor what they have said. Do you understand? So while I'm making the contract with you, I made it very clear that if I am not able to travel as fast as I want to because of breakdown and all that, I am going to repudiate the contract because I see that as a condition to this. Do you understand? Like, I made it clear that I want to travel as fast, and if your engine is not good enough or if your staffs are not efficient enough, I made it clear from the beginning that I'm going to repudiate and I'm going to look for someone else, and you admit, you agree to it. Then why would the court then begin to say, oh, we don't know? No, I said it, that this is it. So it is when the court is not clear on what's the condition and what's a warranty, that's when the court now begin to look for, oh, it is too complex. Now when they now tag it a nominate, that's when we then begin to look for whether or not it substantially deprives them of the benefits. Before we begin to look at whether or not something substantially deprived, we must tag it innominate first. Do you understand? When you are given a contract law question, right? When you are given a contract law question, a problem question, and then you are told to look at terms of contract, the first thing you should look at, does this thing fall under terms or is it mere representation? Once you have looked at the text, okay, this is a term of contract, very good. The next thing, can I classify this thing easily to condition or warranties? And I told you in my last class how to classify when something is mere collateral and all that. But if you see that to one issue or to one clause, there are so many things to be ascertained for us to get that clause. Seaworthiness, there are so many things to be ascertained for me to get what is seaworthiness. It is likely that it will not be a condition, except it was stated that in the event that this and this and this, it was enumerated what are those things that will be broken that will amount to a condition. Do you understand? A breach of a condition, well, for it to be repudiated, the parties had stated it, then innominate can no longer operate. But it wasn't stated between the parties, and then now one person wants to repudiate, and you cannot clearly pinpoint which one is this, which one is that, you know, which one is condition, which one is warranty. Then you just have to use the innominate term. Do you understand? So you don't activate substantial benefits yet until you ascertain that it is of a complex nature that you cannot use a condition or warranties to settle it. It's when you can use condition or warranties to settle that you then begin to use innominate. Do you understand? So let me take it again. When you are seeing a contract law question, right, and you are looking at terms, right, what do? You look at, does it fall under mere representation? No, it's not mere. This is a term. Good. Then the next question, is it condition? Is it warranty? You cannot get if it's condition or if it's warranty. The parties did not agree on whether it's conditions or warranty at the time they were entering, and you are trying to get, but they are too much. Like they are listing. If they just list one for you, that it's this one that they are fighting against, then obviously you should be able to get it now. They said it's just one thing, right? Let's say date was what they were fighting against, or arrangement was what they were fighting against, or maybe color of dress was what. Do you understand? There's no need for substantial benefit. It's one. If it's two things that they are fighting against, if they are reconcilable for you to tell this, but if it's more than two, then you know that because these things are more than two, how do I pinpoint it to a condition or pinpoint it to warranty? Because they are more than two, they are of a complex nature, then you then have to fall down to innominate or intermediate term. And then once you now say these will come under innominate or intermediate term, then you now consider all of them together and ask yourself, do they substantially deprive the innocent party of the benefit? You put all of them together when you are saying that. when you're looking at conditions, one clause condition. But when you're looking at innominates, you put all of them together and ask, when all of them are joined together, do they deprive the innocent party of the ability to substantially get the benefit of the contract? Do you understand the difference now? Let's continue. What's time?
35 minutes.
Okay, so let's continue. Now, according to the court, although there were many contractual, there were many simple contractual undertakings which could be identified per se as either condition or warranties, there were, however, many other contractual undertakings of such a complex character which could not be categorized as either conditions or warranties. That is, can you see that? They were so complex that they cannot be considered as what? Conditions or warranties. It is to this third group of cases that the test of substantial benefit is applied. The seaworthiness test was such a complex undertaking, incorporating both trivial and fundamental requirements, that it was clearly a clause within the third category of terms or innominate terms. Innominate terms. In this case, the breach only entitled the charterers to damages and not repudiation. Like I told you, is it such that you can no longer use the ship? If you can no longer use the ship, then it has deprived you of the substantial benefit. But if you can use the ship, but it's just that you'll be delayed, then you haven't been substantially deprived of the benefits. Do you understand? And that's how the court applied it. So let's continue from that case to another case. Now, this doctrine under which a new class of terms, the intermediate or the innominate term, was recognized, has received general, though qualified, acceptance. If we look at the case of C-Have versus Bremer. C-Have versus Bremer. So we have CEHAVE versus BREMER, also known as Answer Nord's case. Now, in this case, let us look at what Lord Denning said in this case. Now, we have a German company sold 12,000 tons of the United States citrus pulp pellets to be used as cattle food to a Dutch company for about £10,000. So, a German company sold let's say citrus pulp for food, that's cattle food, to a Dutch company. It's still the same thing. German company, Dutch company. Dutch is from Netherlands. Sorry. So a German company sold this thing to a Dutch company, and then the contract provided that the goods were to be delivered in good condition. So what we are considering here is, what is good condition? Are you listening? What is good condition? You can see that we cannot tell if it will be able to fall into, because there are so many things under what will be determined to be good condition. Do you understand what I'm saying? You can't tell what to be good condition. Do you understand? Like, do you mean that it should be delivered, let's say, without it being mixed with something? Like, specifically, let's say it should be delivered without it being mixed with maybe ants or something like that, because if it's cattle food, then it might be susceptible to insects. So if you are saying that it should not be delivered with, all those insects in it, you can say that that's direct. We can tell whether or not if it's delivered with insects, it will amount to. But when you say good condition is such a nature that I don't know. Do you mean that fire should not destroy it? Do you mean that water should not destroy it? Do you mean that heat should not destroy it? Do you mean that, like, what do you mean when you say good condition? When you say good condition, there are so many other things under. If you say, if fire destroys it, then you get. If fire destroys it, I repudiate. If water destroys it, I repudiate. So if you say water destroys it, the court will still have to look whether or not is a warranty, but it's more direct for me to know whether it's a condition or warranty. But in this one, they said that the contract provided that the goods were to be delivered in good condition. On arrival at Rotterdam, that's Netherlands, from the United States, it was found that a small portion of the cargo had become bad as a result of overheating. The buyers rejected the goods and claimed a refund of the purchase price. The court ordered the sale of the whole cargo, which was bought by third party for $30,000 and resold to the buyer for that price. Now, let's go to the judgment of the court. The court held that apart from conditions and warranties, there were a third type of term, which is intermediate term, the effect of which depends on the gravity of the breach. If the breach goes to the root of the contract, the injured party is entitled to treat himself as discharged. If not, entitled to do so. If not, he is not entitled to do so. Rather, according to Lord Denning, the first task of the court when faced with breach of contract suit is to see whether the stipulation breached is on its true construction is a condition strictly so called. Now, this is a stipulation such that for any breach of it, the other party is entitled to treat himself as discharged. Secondly, if it's not such a condition, then look to the extent of the actual breach which has taken place. If it is such as to go to the root of the contract, the other party is entitled to treat himself as discharged. Applying this test, it was held that the clause stipulating that the shipment was to be in good condition was neither a condition or a warranty, but an intermediate term. And since the breach did not go to the root of the contract, the buyer was not entitled to repudiate the contract. Although Lord Denning did not, give an exposition on what we talk about, how to activate intermediate term. But if you look at the rule which I was talking about through Lord Diplock, if you look at the rule, when you are determining what a good term, what good condition is, how do you tell what good condition is? When you say that they should arrive in good condition, how do you determine? So because there are so many things to look at when we are looking at the determination of good condition for the cattle food we are talking about, there are so many things to determine. So because we do not know everything, we then have to call it an int. That's why I told you that in exam, if you see something that it is not so direct as to you quickly saying, oh, this is condition or this is warranty, then it's intermediate. But if you see something that you can directly say, there are two ways to know intermediate. Number one, if they list about 2, 3, 4, 5 things together and you can't sever them, they are all joined together, then you know that this is an intermediate term. Even if they list one thing, but that one thing that they are listing is so wide in nature that you cannot say that. Do you understand? For example, good condition is so wide in nature that it's hard for me to say, it's condition or it's warranty, then it's intermediate. Do you understand? You know what I said earlier is when you have 2 to 3 things that you cannot sever, you have to read all along and then come to the conclusion. But now, when you have one thing, but that one thing, you don't know where to put it, whether this or that, because it is not direct, then you put it under intermediate. So once you've said a term is intermediate, then you now go to another step. Once you say a term is a condition, it can be repudiated immediately. It doesn't work like that with intermediate. Once you've said a term is intermediate, all that is telling us is, another step. Can we then say that it goes to the root of the contract in such a way that the other party will substantially be deprived? Now, they said a small portion. He ordered 12,000 pallets or whatever, a citrus pulp rather, and then out of the 12,000, a small portion, I want to believe that a small portion there would amount to maybe 2,000. So if 2,000 citrus pulp, got lost or got destroyed, the 10,000, it hasn't been substantially. Do you understand? For you to say something has been substantially, it means that it must have crossed 70 to 75%. So what's 50% of 12,000? 6,000, right? 6,000 is still not substantially. If I'm to apply the test, is about probably 8,000 of the pulp. You want 12,000 of something, and about 8,000 is already lost. So 4,000 left, or 9,000 is already lost. So 3,000 less of the citrus, that's a cattle food. Do you get what I'm saying? So when you're talking about substantial benefit, it must be such that the other party would have been stopped. Do you get? So, about 2,000 left for him out of the 12,000, so like 10,000 was destroyed. Then substantially, he has been deprived. Do you understand what I'm saying? So that's what was held in the case of Seha versus Bremer. Now do note that the court did not say to what extent in terms of the number. I'm just the one giving you a reasonable conclusion that, oh, if he had been, the court might have said, it have been substantially affected and all that and all that. But at least you now know the whole substantial benefit test. The fact that something has been termed to be intermediate does not automatically give the other party the right to repudiate. You still have to prove that you have been substantially deprived of the benefit of the contract. Unlike conditions, the moment you prove that something is a condition, you have the right automatically to ask for repudiation. You don't need to prove anything. But so let me give you on the board. This is a what, right? What is the clause? The moment you realize that the clause is a condition, the moment you realize the condition, you go straight to repudiation. Straight up. You don't need to start proving any long thing. But yeah, when we say what, and then they say that the what is innominate, how do you know that it's innominate? Because it's too complex to classify in condition or warranties. Then what do? Immediately you don't get to repudiation. You still have to prove one more thing. Does it substantially affect you? If you have been substantially deprived of the benefit, that is when you can now repudiate. Do you understand? So what condition? Repudiation, right? What is the clause? Is the clause a condition? Okay, then you can repudiate. What is the clause? Is the clause an innominate term? Oh, it's an innominate term. You can't repudiate immediately. You still need to ask whether or not it goes to the substantial roots of the contract and you are deprived of benefits. That is the only way you can repudiate. If not, the next thing is damages. If it doesn't go to the roots, then damages. Are you seeing that? Are you seeing the difference between the both of them? So good, let's continue because we are already getting to the latter part of the class. Now, recent decisions have established clearly that although this third category of contractual terms has been recognized and accepted, the traditional terms, condition and warranties are still relevant and applicable in a large number of situations. Furthermore, in the interest of certainty of the law, once a type of clause in a contract has been accepted previously as a condition per se, it will continue to remain a condition and it will not come under the new rubric of intermediate terms. Thus, in the case of Mihalis Angelus, the Mihalis Angelus case, we are done with Seha and Bremer. We have also done with this, so we are almost at the end. So a charterer of ship was held entitled to repudiate the contract because the ship, which under the terms of the contract was supposed to be ready to load at July 1, was not ready to do so until July 17th. I know my note said July 7th. That was a mistake. Until July 17th. The Court of Appeal dismissed the notion the readiness of the load clause was not a condition but an intermediate term. It was held that a condition in the old sense of the word condition, i.e. when it is broken, the other party can, if it wishes to elect to be released from the performance of his further obligation under the contract. Amongst the reasons provided by the court was for taking this stand was that it tends towards certainty in the law, and the clause expected to load has always been regarded as a condition. So now, I know I've said so much English, and you guys are already wondering what this English is. This is what I'm saying. In as much as the court recognizes intermediate terms, right? In as much as the court recognizes intermediate terms, once a thing has previously been recognized as a condition, it will continue to do so regardless of whether or not, people want to call intermediate terms. So, according to this court, time will always be a time will always be of the essence of a contract. When something is supposed to be done per so time, then that will always be a condition. And I will personally agree that it's a condition. Why? Because it is straightforward, right? This is it. Deliver on the 7th. Yeah, they said come and do something on the 1st, and you did not do it till on the 17th. Come and load on the 1st, you didn't load till on the 17th. That's the condition that has been broken. Do you understand what I'm saying? So time, for example, will, except the parties expressly said that time will not be of the essence. Time on normal day will be of the essence in the contract, and a breach of the time clause will always be a breach of condition, because according to me it is straightforward. It's either a condition or a warranty, and to me it's a condition. So a breach of it automatically gives the other party the right to repudiate. That was what the court in the case of Mihalis Angelos said. Now let's go to our last case for today. And our last case for today is the case of Bunch Corporation New York versus Strada Exports SA Panama, where a seller of goods was held entitled to repudiate the sale agreement because the buyer, who was required by the terms of the contract to give the seller 15 days notice of when a vessel to ship the goods will be ready, gave only 13 days notice instead. It was held that the stipulation as to date of readiness was a condition, and that notice short of the stipulated period by even 1 day was a breach of such condition. So you can see what I'm talking about. So when you cite this case, you also cite this case, in as much as they are inanimate terms. Time is not a complex thing. That's one thing. Inanimate terms would only arise when the clause is so complex that we cannot put it as whether or not it's a condition or it's a warranty. To want to begin to blur the lines as to I don't know, it's clear. Don't blur the lines, make it clear. If it is certain, this is what we are talking about here. Time. Why are we using inanimate? What is complex about time? Deliver on so day, you did not deliver. Is this a condition or a warranty? Simple. Do you understand? It is maybe when the time becomes so ambiguous, that's when no, it's not ambiguous. They said give me 15 days notice in Bunch Corporation New York versus Strada. Give me 15 days notice. You gave just 13 days notice. What is ambiguous there? What is so complex there? Do you understand? So in as much as even the tradition of the court is, once something has been recognized as a condition, it will continue to be a condition. Do you understand? Except it becomes so complex that we can no longer say it's a condition, but normally it's a condition. But time is always of the essence of a contract, except the parties say time will no longer be of essence. Then we still not call it inanimate, we will call it a warranty. If the parties tell themselves that time will not be of the essence, there is only going to be a warranty, not an inanimate term. Inanimate term can only be activated when the situation is too complex as to put it on condition or on warranties. So with that, let's go to the latter part of my note, which says, according to the court, in mercantile contract stipulations as to time were always treated as being of the essence of the contract, i.e. conditions. Such stipulations were not susceptible to the test propounded for intermediate terms. Apart from this, English law did recognize as condition contractual terms which did not pass the test propounded by the court in the Hong Kong 4 case. All told, the court in the Bunch Corporation case was very critical of its own earlier decision in the Hong Kong 4 case, and appeared to be questioning not only the validity of that decision, but the very existence of intermediate terms. It might therefore be stated that a large majority of terms will continue to be recognized as either conditions or warranty. Only in minority cases will a term be treated as intermediate, and this will be when such a term is of such uncertain, can you see that? This will be when such a term is of such uncertain or complex nature that it cannot be decided on the face of it as to whether it's a condition or a warranty. In such a case, the remedy available to the injured party would then now depend on whether the breach has deprived him of substantially the benefit of what it was intended he should obtain from the contract. Finally, it should be noted that when a court decides that a breached term is either a condition or a warranty, the court is examining the quality of the term broken and is basing its judgment on this. Whereas when it holds that a term is an intermediate term, the court considers the effect of the breach and bases its judgment on that factor. One other factor to note is that where parties stipulate in advance that the consequence of a breach of a particular clause in a contract is to be, this will be accepted and enforced by the court. Now, before we get to the last rule, I just want to make a recap before we then end our lecture for today. What's the time? 55. Okay, good. Now, this is what I'm telling you. Yeah, what I'm saying is this: when you are looking at conditions will always be condition. Warranty will always be warranty. Straight to the point. When you are looking at a warranty, is it collateral? If it's collateral to the contract, it's a warranty, and therefore what you can sue for is damages. If it is not collateral, it is condition. Straight to the point. If it's not collateral, is what? It is condition. Now, the only time intermediate comes in is where we can't classify. Is this condition? Is this warranty? Is this condition? There is this thing that people say that no, when you sold this thing into a contract. No, don't confuse yourself. When something is a warranty, it is collateral to the contract. It is by the way of the contract. And I told you in the last class, when you did not come for rehearsal, but you could have still made it to the program. Even when you made it to the program, you wore a blue dress instead of a green dress. All those kind of minor things that does not affect the contract itself, those things will be termed as warranties. But when they tell you to come and perform for 5 days, you did not come for 3 days, you are coming for on the 4th day. What are you coming to do? So that is a condition. Why? Because it is clear cut. The only time you activate intermediate term, when you cannot, it is too complex that you cannot categorize here or there. You can see that even the court in Bunch's case, the same court that delivered this decision is the same court that delivered this decision. The court here is beginning to ask itself, are you sure that we really want to be confused? Because, do you understand? But I don't think there's confusion here. I think it's straightforward, actually. I personally think it's straightforward. So, when you are looking at something individually, is it condition, is it warranty? Straightforward. But when it's such complex that you don't have to look at 2 to 3 or 4 things together, you look at it as a whole. In condition, you don't look at condition as a whole. You look at it as a subject matter. One thing, you did not give me the goods on the 7th, you gave me the goods on the 9th. You did not give me the notice, 15 days notice, you gave me 13 days notice. You did not, do you get? You did not do this. It's direct. Is it a condition or a warranty? If it's a condition, I repudiate. Do you understand? Now, if you are now talking about intermediate, I cannot pick points because there are so many things. There are so many factors to be taken into consideration. So when I put all those factors together, I then need to ask, does it substantially deprive the other party? Do you understand? Here we're talking about seaworthiness. What is seaworthiness? What can we term that is seaworthiness? We have to look at the engine, we have to look at the workers, we have to look at other things. So we look at all those things together, and then when we have looked at them together as a whole, then we now conclude, can we say that the other party has been substantially deprived of the benefits? The other one, this case, was on what? Was on good condition. What is good condition? Is it that it should not have been destroyed by fire? It should not have been destroyed by water? It should not have been destroyed by insects? It should not. What exactly is good condition? So because we don't know what good condition is, then we have to look at all the relevant facts before us and then look at, has it gone into, the contract so much so that he has substantially deprived the innocent party. So once you've done that, like I told you, once you've gotten your what is the clause? If it's a condition, you go straight to what? Repudiation. Simple. But once you've gotten what? If it's an innominate term, you don't go straight to repudiation. You first go to what? Is it substantial to deprive the other party of benefits? It is only then, after the next step, that's the substantial benefit test, that you then repudiate. Do you understand? And then let us go to the latter part. The latter part is talking about where the other parties have agreed. And I told you earlier. So it says one factor to note is that where the parties stipulate in advance. This is what I was telling you. We will not need to be talking about non-limit or innominate if the parties have actually stipulated all these things in advance. It's where the party does not stipulate it in advance that will now begin to bring them together to look at which one is innominate or intermediate. So one factor to note is that where the parties stipulate in advance that consequence of a breach of a particular clause in a contract is to be that this will be accepted and enforced by the court. Thus, if a party stipulates that the breach of a clause A is to result to damages and clause B is to result to repudiation, this must be respected and enforced by the court. You see that? Once you stated it from the onset, which is the reason if you are a very good contract lawyer, these are the things you put in your agreement. Conditions and warranties. Say once you breach this, that's the essence of being a very good contract lawyer. After you've done offer, acceptance, consideration, you know all the laws regarding that. Another thing that is very key because of the outside world, not just your exams, but the outside world is also the this element of conditions and warranty and how to wiggle around it and make sure that you do the best to captivate the interest of your clients, so to say. So once you've stipulated it in the contract, the court will respect it. However, it is not sufficient to call a clause condition and another warranty. It is for the court to classify terms in this manner. Parties may find a clause referred to as a condition may on examination be classified by the court as a warranty or other classes of terms. Now, this one is for practice. You don't need it, so to say. It's so to say for practice. Just know that, when a clause is written as a condition, the court will respect it, but it's not in all times that the court will respect it. I want to go further into explanation and all that, but I don't think it's relevant right now. But you get the gist, and that's where we are going to end our class for today. How many people are there? So, is there any question before I end the class? Because we still have a last class to go, which is fundamental term. Fundamental term should take just about 30 minutes, but that's going to be after this class. So, does anybody have any question? So while we are looking at whether or not there are questions, do not forget that we started from the definition of innominate terms as opposed to conditions and warranties. And I told you that you should look at this case, very important. You see, when you're answering innominate terms, you see these cases, you might maybe not cite this case, but you must cite this one. In short, if you don't cite, there's something wrong with you. You must cite this one, that's Kawasaki. You must cite this one because this one is the one that gives this one more efficacy. It says, we agree with this. Lord Denning. Lord Denning says, I agree with Lord Diplock. And then you look at the Bunch case as well. You get. But I'll just advise you, know the four of them. But if you can know these three, it's fine. Do you understand? So, and then you also understand that once you have located something, if it's a condition, straight to repudiation. But if you have located something and it's an innominate term, then you don't go straight to repudiation. You have to look at the substantial benefits and all that. So, in the absence of any question, thank you so much for watching to the end of the lecture. Our next class is on fundamental terms and it's going to be in next 30 minutes thereabout. So I will advise that you stick around for the next class and final class for today. Our subsequent classes will be communicated as well. Thank you so much for watching to the end of the video. I will see you in my next class.